Good afternoon, everyone. Thank you so much for being here for Intersections. Intersections is different conversation every month, and we try to do so with civility and model civility, but also to have interesting and sometimes difficult conversations. And so I'm Connie Ryan. I'm the Executive Director of Interfaith Alliance of Iowa. We host this conversation each month essentially during the school year. So May will be our last gathering. We don't generally meet in June, July, August, but then we'll be back in September. We are really grateful to Christ Episcopal and particularly to Libby Slappy and Charles Crowley for having us here. Normally, we've been at First Presbyterian Church and have been for most of the time that we've had Intersections, but they had a little water issue, and so, or a big water issue, and so we're grateful to Christ Episcopal for hosting us these last month and this month and also in May. So glad to be here, and then we'll figure out for the fall what will be happening. So, so in May, I'll just let you know that we will have Max Mowitz, who is one of the staff at One Iowa. They also run the Iowa Transgender Mutual Aid Fund. And so they will be here to talk about transgender issues. And we scheduled that last fall before this legislative session, and who knew that it would be such a timely conversation as well. So they'll talk about being transgender in general, but also what's happening at the State House. So you'll want to come back. That's Intersections is always the first Friday of the month. So yes, ma'am. Yeah, so Libby's just saying the bathroom is through that door and a little bit to the right if you need to. And we are very informal with Intersections, so just take care of whatever you need. And there is cake over here also, so feel free to come. And even if you didn't order lunch, that's totally fine. You can come. There's cake and there's a few cookies, I think, left. So feel free to help yourself and drinks as well. So I am particularly delighted. Sorry, I'm trying to do two things at once, and when you get older, that doesn't really work very well sometimes. So, particularly delighted to have my friend Rachel Paine Caufield with us today. We've known each other for, I don't know, 12, 13 years, I think, doing Justice Not Politics work together. And Professor Rachel Paine Caufield earned her PhD at the George Washington University in Washington, D.C., specializing in American politics and political science methodology, and her BA at Hood College in Frederick, Maryland, majoring in political science and mathematics. So smart, we'll just put it that way. And you'll learn that also as she speaks. She joined the Department of Political Science at Drake in 2001 and teaches courses on American politics with special attention to political institutions, Congress and the legislative process, judicial politics, and the American presidency. Prior to joining the Drake faculty, she was research fellow at Brookings Institution in Washington, D.C., studying the relationship between the U.S. Congress and U.S. Supreme Court. And she is a board member of Justice Not Politics, which is where we get to see each other many times over the years. So I'm going to bring Rachel up and just help to welcome her to the podium. Thank you.
Thank you. Good afternoon. Thank you all for being here today on a lovely day. Thank you for inviting me to be here today. Connie wrote me and asked if I would speak about the politicization of the judiciary. And I have to tell you, that is just a huge topic, particularly because my area of research and teaching expertise is in judicial politics. So everything I do is about politics in the judiciary in one way or another. So I'm going to cover a lot of ground, I guess, and in doing that, there will be some items where you may have some additional questions, or we may want to dig a little bit deeper, and I'm happy to do that during the Q&A. But I'm going to start today with a story. Once upon a Once upon a time, there were a group of very smart people who joined together, and they were wise, and they came together to set up a new government. And among the government institutions that they designed was a court. And that court would resolve disputes, and it would maintain peace and tranquility throughout the land. The court would be separate and distinct from the nastiness of politics. It would be removed from hostility and aggression. Partisan hotheads would have no role. This court would heed the law without fail. It would be a beacon for justice. It would make sound, reasoned, independent rulings based exclusively on law. It would advance individual liberty. It would ensure equal rights. It would keep government power at bay. It would be virtuous and unsullied by mean-spirited partisan conflict. And so we would live happily ever after. And then, wait for it. A monster came. And then a monster came. That monster was named politics, and it fundamentally changed the court. It corrupted the court. It made the court into a mean-spirited, nasty place, and the court bowed down to its powers, and it succumbed to all the worst aspects of politics. The court became partisan and divided, and it no longer cared about justice. And that's the story that we so often hear about our courts today, that some untamed force has come in and taken control of something that is otherwise meant to be and would otherwise be good and virtuous. But I want to start today by saying that that story is completely false. All of it is completely false. The monster of politics has always existed in our courts from our very earliest days. Our courts are, in fact, political institutions. And that's not to say that they've always succumbed to politics, but that politics is inherently a part of the court system. Our courts are created by political documents. Judges are appointed in political processes. Cases raise political issues, and the court is asked to resolve those issues. You may recall once upon a time talking about Marbury versus Madison, the very famous case from 1803. It's in every single government and civics textbook throughout the country and around the world, really, because it created the power of judicial review. And that's the power of the courts to review acts of legislation and determine whether they are constitutional. It essentially gives the power to strike down acts of law that have been passed through democratic processes, to act in a counter-majoritarian way. And that is political power. But the part of the story that's often ignored or glossed over in talking about Marbury versus Madison is that the case considered the question of whether a president, President Adams in this case, could pack the court with ideological allies. Right? So just 11 years after the creation of the federal judiciary, there were already high-level attempts to bend the courts to the will of politics. Politics have always been in the courts. So I come at this from a political science perspective, and the framework that we often use is called institutional design. And I like to think of institutional design as this. Excuse me. How do we tame a monster? Look, we can tame the monster. Given that our courts are inherently political, how do we set up processes to make them less political, to channel politics in ways that are productive rather than destructive? And anyone who has attempted to create any new organization or institution knows that planning for the future and mitigating against harm and minimizing intrusions by anyone who would seek to undermine the fundamental goals is the first task of creating that organization or that institution. It's true in everything from a garden club to a local PTA to a national government and, in fact, a court. Institutional design is just the process of thinking about future threats and guarding against the worst possible outcomes. And in the case of our courts, it means setting up rules and procedures, processes that insulate the court from entrenched interests, overt partisanship, corruption, greed, or bias. We can recognize that politics exists, but we can also find ways to protect our courts from the worst effects of politics. But first, we have to know what our aspirations are. So every time I teach judicial politics, I start the semester by asking my students to write a paper. I ask them to identify what our goals are in creating courts. What is it that we want our courts to be? What is an ideal court system going to look like? And I ask them to talk to their friends and their family about visions of an ideal court system, and they generally come up with a list. You can see kind of the leading identifying values that they choose. And that list looks a lot like the storybook version, right? That our courts are going to be fair and unbiased. They're going to be consistent in their rulings, independent from politics. They're going to be respectful, both in terms of the use of political power and the treatment of individuals inside the courtroom. They're going to be knowledgeable. They're going to be efficient, make decisions in a timely manner. They're going to be diverse, represent the community that they're working with, and they're going to be responsive to the interests around them. The mythology, this is the mythology of the courts that we love to celebrate. And I believe that all of these things are possible, to be clear. But I also believe that none of them will occur naturally. And so we have to create and maintain courts that advance our goals. So why does it seem like somehow or another we have failed to do that? What happened? So this is a nice long list, and it covers a ton of American history and big political developments. So I am necessarily going to be incomplete here. But we can start with the fact that law is inherently ambiguous. Law is rarely well articulated. Law can be confusing, contradictory, and just utterly undefined in some areas. And there's a lot left to interpretation. There's a lot of latitude. Good, smart, well-intentioned people can often come to different conclusions about what the law requires. And we have to remember as well that the creation of our earliest courts in the United States, and that includes our federal court system, it happened during a period of time where there were no political parties. They did not envision or plan for the effects of political parties. So the monster that they envisioned and the monster that they guarded against, it took on very different forms as parties began to come together and as they formalized the contestation of political issues and personal rights. In addition, by the late 1800s and early 1900s, we begin to see not just political parties, but we see interest groups come together and exert pretty powerful political power. So we think about the labor movement, we think about women's groups, financial interests, the National Grange on railroad regulation. We see the temperance movement, the NAACP and the American Medical Association form. And these groups start to mobilize people and bring forward unique agendas to press for specific policy outcomes. And this, of course, combines with waves of democratization, where political processes become more public and the public comes to expect greater influence over its government institutions. And of course, then we have the New Deal, which dramatically increases the size, the scope, and the complexity of the national government. It gives every American a stake in policy questions, including those that are being considered by our courts. Excuse me. And this fundamentally changed the relationship that we have with government as American citizens and the relationship that we expect our government to have with us. It changed our expectations for our courts as well. It's not a surprise that FDR put forward his major court packing plan after encountering policy-based conflict with the US Supreme Court. And as we move into the more modern period, we see the rise of media, and we see efforts to create a national dialogue around our courts, around the power of our courts. This rhetoric comes to shape public debate about not just abstract legal issues, but specific judicial outcomes. And that, of course, comes to a head for the first time, and in conjunction with a very robust interest group strategy during the nomination of Robert Bork. During today's modern party alignment, the parties have become more polarized, and that rhetoric has taken on new political meaning, not just in the halls of government and not just among interest groups that are kind of sitting around tables all over the country, but among polarized Americans in every household, in every school, across, like everywhere, right? Everybody's having this conversation now. And through all of this, we have a number of direct interventions. We have political efforts to shape courts and the makeup of courts, political efforts jockeying for power over who becomes a judge, what cases can be heard, how judges are held accountable, and what decisions courts will make. So let's start with the national level. What is the collective result? We're going to blow up some more of the myth here, and that is the US Constitution includes only 350 words in Article 3, creating the federal court system. The entire federal court system is created in 350 words in the US Constitution. Right? And much of it, by the way, is actually defining the crime of treason. Right? For anyone who has tried to tweet, I'm not a tweeter, but for anyone who has tried to tweet, condensing complex ideas into a small number of words is hard. One of the other class assignments that I've had sometime after they've identified their values, I've asked them to create their court system using 350 words. They cannot do it. This is a complex question. And yet somehow or another, we only have 350 words. The federal court system is remarkably underspecified in the fancy language, right? Article 3 basically just says we will have a Supreme Court. That's it. We will have a Supreme Court. It doesn't say anything about the number of justices, the size and structure of the courts, doesn't say anything about the qualification of judges, the process of reaching decisions. None of that is included in the Constitution. And the general explanation for that by political scientists, by the way, is that it was hot. And there were a whole bunch of people stuck in a room together without air conditioning during a time when they had to wear like silk stockings and heels and elaborate outfits and powdered wigs. And they were hot, right? They said spend all this time thinking about and constructing a legislative branch, Article 1, and a little less time thinking about and constructing an executive branch, Article 2. And by the time they got to Article 3, they were really ready to go home. So they said, we're going to have a Supreme Court, and that's it. They basically said, we're going to let Congress decide everything else. But what it means is that most of our national court system is either established by Congress, that's a political process inherently, right? Or it has been guided by an evolving set of norms and informal rules that have never really been made explicit in a thoughtful and well-defined way. And all of those loosely developed norms and rules leave a lot of room for development of political strategies. It leaves a lot of room for people to play politics with the courts. Presidents in particular have gotten really good at this. They've developed very sophisticated vetting systems. Whole staff units within the White House are now dedicated to kind of soliciting names and figuring out what people's likely voting records will be if they're appointed to the bench. National organizations are happy to create litmus tests and make recommendations and groom candidates for judicial service. And obviously, we can think about the Federalist Society. They were kind of the first to pioneer these tactics. And that has really changed a lot about what's going on in our national courts. So this is just kind of a snapshot. 1967, and these are some of the cases, the kind of big social questions that we may still know of that were being considered in 1967. So it's not like nothing important was being talked about. And you can see among the US Supreme Court at that time, so what we've done, we've taken little photos of all the justices, right? And we've arrayed them based on their voting record at the time, from the justice who had the most liberal voting record, that would be William O. Douglas, right? All the way over to the justice with the most conservative voting record on 1967, that was Justice Harlan. And the color behind them is the color of the president who appointed them to the court. And what you can see, right, is that there's a wide spread here, right? So you have some more liberal justices who are appointed by Republicans, and you have some more conservative justices, Justice White and Justice Black were appointed by Democrats, and yet they're among the more conservative justices on the court, right? So you have some kind of intermingling of party affiliation and presidential selection and ideology once justices arrive on the bench. Fast forward to 1988. And here, right, again, some big cases are going through the courts. And we do exactly the same thing. Justice Marshall, most liberal and appointed by a Democrat, right? On the other end, we have Justice Rehnquist, the most conservative, appointed by a Republican. But you can see, right, virtually all, except for 7 of the 9, are appointed by Republican presidents. And yet they're still pretty widely dispersed across the ideological spectrum. Fast forward to today, and I should have changed the date here because obviously this was before the appointment of Justice Jackson, right? But you can see that on the Roberts Court, the divide has shifted, right? There is now perfect alignment between a justice's voting record and the party of the president who appointed them to the bench. That's new. And basically what it means is that presidents don't make mistakes anymore, right? That sophisticated political strategy that the White House has developed is working. It's working really well. And let's talk for just a second about Congress, because Congress is helping to facilitate this, right? Congress has a lot of control. They initially, right, we talked about informal norms and rules that have been set up around these processes. Congress had a lot of these. Congress had an informal norm of always kind of requesting, getting, and following ABA qualification recommendations. Congress had a norm that we called the blue slip, where home state senators would have an opportunity to effectively determine whether or not somebody who would be appointed from their state would continue on in the confirmation process. They set up roadblocks. They had checkpoints along the way to guarantee that the confirmation process would weed out unqualified or overtly partisan nominees. But Congress has done away with those processes. Congress has largely done away with the ABA qualifications rating as a pretty firm norm. Congress has gotten rid of the blue slip process. And of course, Congress blew up the filibuster using its nuclear option. Nuclear option, by the way, one of my favorite phrases in politics. The nuclear option did away with the filibuster. And what that means is that a very small and temporary majority in the US Senate can push through as many judicial nominees as they would like. And they can do it quickly. And there is no input, none, from the minority party. They do not have to listen to a single voice in the minority party. So those roadblocks and checkpoints have been pushed to the side. Combine that with the fact that gridlock in Congress has ceded policymaking to the executive and the judicial branches. When Congress can't make a decision on an issue, they push it off. So the president does a lot of governing through executive orders, and a lot of governing, a lot of national policy making is made by cases that are being decided by the US Supreme Court. That, of course, combine all of that, right? And it means that all those kind of checks that have been built into our system are not serving to insulate the judiciary anymore. Just to give you a basic idea of what this looks like, this is the appointment process, and you can see how much more quickly President Trump was able to nominate and confirm judicial appointments during his time in office. And, right, there's a reason why today, after only 4 years of a Trump presidency, right, about a third of our Supreme Court and appeals courts are made up of Trump appointees, and a full quarter of our district courts are made up of Trump appointees. Right? That kind of variation, that quick confirmation and remaking of the federal judiciary with each president, that's not good, right? That's not what we initially intended here. Those roadblocks were meant to stop that from happening, but fundamentally, our federal judiciary has been remade. It's been remade very, very quickly as a result of seemingly small changes, right? Getting rid of the blue slip doesn't seem that dramatic to most people. But when you combine it with other things, all of a sudden, it produces pretty dramatic outcomes. It's also led, by the way, to much more polarized public responses to the court. So this is a really fancy little chart, but basically they just asked a bunch of people. They said, okay, so, right, generally we think that Supreme Court justices should not bring their own political views into how they decide major cases, right? So this is the percent of people who say that justices are doing a good or bad job of that. And what it tells us is that we firmly believe that judges who have been appointed by presidents of our own party are really good at leaving their politics behind and only following the law, but we are equally convinced that anyone who is appointed by a president of the other party is just fundamentally unable to do that, right? So our responses have become completely polarized and political. So how does it trickle down into the states? What are we seeing across the states? So states are really interesting in this debate precisely because so many state courts have dealt with questions of political influence for such a long period of time. And they take on a really interesting array of different forms. I chose one example, and this is Boss Pendergast in Kansas City. For those of you who might have spent some time in Kansas City, it's kind of a legendary political machine. And what would happen, Kansas used election of judges. And so just as the boss, the party boss, would choose candidates for other offices, Boss Pendergast would choose a slate of individuals who would run for judge. It didn't matter if they were qualified. It didn't matter if they were lawyers. Didn't matter if they had any experience or knowledge. They were his ideological allies. Sounds a little like President Adams in 1800, right? Like, let's stack the courts with our ideological allies. But it came to a head, and one of the things that started to happen is that states started to, and it wasn't just in Kansas City, obviously, things like this were happening all over the country. And so the states started really trying to think critically about how to alter their courts. It led to a confrontation, right? Lots of questions of institutional design here. And over time, states have created an amazing patchwork of rules, laws, regulations, structural design. It really is remarkable how much difference there is among the states. But generally, the national trend was that states would usually start with an appointment system, and then there was a wave during the Jacksonian period where states moved to partisan elections to select their judges. And then there was a backlash to that as partisan elections very predictably became very partisan. right? And so some states said, oh, this isn't working. Let's have nonpartisan elections. But nonpartisan elections, a lot of people have no idea who's running because there's not an R or a D next to their name. And so people stopped voting. And so a lot of states said, we need to be doing better than this. And so beginning in the 1940s, states began to adopt merit selection of judges as an alternative. We still have states that use appointment systems. We still have states that use partisan election systems. We still have states that use nonpartisan election systems. And we have a number of states like Iowa that adopted merit selection of judges. Merit selection, for those who are not familiar with the system, it was intended as a way to make sure that no political figure had unfettered control over the selection of judges. So it created a commission. And the commission would be made up of lawyers who would be selected by the state bar, non-lawyers who were selected by the governor. They would come together, they would work together to vet applicants for judicial positions. And then they would decide who they thought was the most qualified from among the applicants. And they would make recommendations to the governor. And then the governor would appoint one of those individuals that had been recommended by the commission. And then after a period of time, in most state merit selection systems, after a period of time, the judge stands in a retention election. That's a simple yes/no vote to decide whether or not they will remain in office. So the patchwork of systems that was developed in the states has created a mishmash of monsters, some of them small, some of them bigger, some of them meaner, some of them friendlier, all different kinds of political influences. So across all the different states, we see different ethics rules, we see different election restrictions, different qualifications, different selection systems, different systems to remove justices from office. And periodically throughout this time period, there would be a big political scandal in one state, but the influence of that tended to be pretty localized and temporary. Other than that, it was pretty quiet. Lots of people have said, right, state judicial elections have generally been pretty quiet affairs, pretty sleepy. And that was until the 2000s. Two things happened in the 2000s. First, this national debate, this national rhetoric among a polarized public really came to the states. Right? So the political rhetoric that developed nationally was pretty easily transferred to the states, and it invited a new kind of politics into our state courts. It was well coordinated across the states, and it was very well constructed. It had been developed and used at the national level for several decades at that point. Right? So bringing it into the states was a relatively easy project. And at the same time, a few high-profile groups, led by the Chamber of Commerce, realized that the business of state courts often includes cases that they care about very much. And that's everything from civil liability for medical malpractice to gun rights to taxation issues. And because these elections had been so quiet and so sleepy, and nobody really was paying much attention to them, it was much easier and much cheaper to jump into a state judicial race and have real influence in selecting judges in a state that would then, in turn, potentially lead to more favorable outcomes for these organizations. So they can get some real policy wins out of their state courts. And you can see over time, oh, my little pointer doesn't work on the screen, but you can see over time, right, since 2000, we had a kind of an anomalous year in 2003, and you can see that when they coincide with presidential election cycles, the spending goes up. You can also see the dark bars, the dark part of the bars here is candidate spending. The middle color of blue is spending by outside groups, and the light blue is political party spending in these races. And you can see that as of 2019, well, as of 2017, really, parties had largely jumped out of these races. The money now is virtually all direct contributions to judicial candidates. Think about that for a minute. Direct contribution. Somebody hands money to a judicial candidate, right? somebody who may eventually show up in this courtroom, right? Hands money to a judicial candidate, or an interest group overtly airs advertisements, independent expenditures, right, saying, here's who you should elect. Right? Very public spending of group money. So for a while, this dynamic of big money political influence in judicial elections was really contained. And it was really contained in a handful of states that ran partisan judicial elections, where issues were kind of more at the fore and partisanship was built into the system. And there were a couple Supreme Court cases, Citizens United, which we think about in national campaign finance, but it also affected state races, as well as a case that very few people have heard of, which is called Republican Party of Minnesota v. White. It's where the U.S. Supreme Court said that if you're going to run elections for judges, you have to allow those judges to speak out on controversial social, legal, and political issues. So judges basically got a green light, judicial candidates basically got a green light to speak openly about their political views, which is kind of exactly the opposite of what we might hope that a judge would do, right? Sounds an awful lot like maybe prejudging some of those cases that may end up before them, right? And of course, Iowa becomes one of the first states to face serious money in our judicial retention elections, right? So it starts to spread, not just in partisan elections, but in nonpartisan election states and in retention states. Iowa, in fact, was the first state to have more than $1 million spent in a retention election cycle. And that was, of course, in 2010 after the Varnum v. Breen decision. For those who pay attention to the news, this trend towards big money in judicial elections found its fullest expression in this week's judicial election in Wisconsin. $42 million was spent for a single seat on the Wisconsin Supreme Court. $42 million. That makes it the single most expensive race, judicial race in U.S. history. And it trounced all former records for spending in judicial races. I mean, it's just far and away exceptional, right? 2020, so not that long ago, Illinois is kind of a weird state. It holds a mishmash of elections, but once you're on the bench, once you're on the Illinois Supreme Court, you face retention elections. Thomas Kilbride, who's from the Quad Cities area, so we may have gotten some advertising from this race. Thomas Kilbride faced a vote no campaign in 2020. $10 million was spent against him. So it's not just contested election states. It's happening everywhere where a single seat can become a political flashpoint. Right. Importantly, I'm just going to note this. Importantly, in that Illinois race, the spending to oppose Justice Kilbride, 88% of it came from just two people. So, like those two people, they have a lot of influence over a lot of issues now in the state of Illinois. Right? What was the main issue? Well, so he had made a series of decisions. Medical liability came up. And then there was one, Connie, do you remember the one issue in particular? There was one ruling in particular that they really targeted on, and I don't remember what that was, but he had been opposed in the past. This was his biggest, and it didn't help that he had very tight ties with the Democratic leader who had some questions about ethics. Shall we say it's Illinois? I was going to say, it's Illinois. This is what happens in Illinois. So, and it's not just in elections. Across the country, we've seen a pretty remarkable trend towards special interest engagement in legislative efforts to curb the courts, to basically find ways to limit or control courts in various ways. So this chart shows the number of proposals, legislative proposals that have been introduced in each state from 2008 to 2016. And updated data is kind of hard to get because the sheer number of these proposals and the diversity of attacks on courts and court structure is, I mean, it's a bear to keep up with, right? It's a lot. So many of these state legislative efforts are coordinated across states. So the same language, the same proposals are being put forth in a lot of different states. So they're being coordinated through a number of different groups, one of which is the American Legislative Exchange Council, or ALEC. And that's a conservative group that disseminates legislation across the states. And you can see in Oklahoma and Tennessee in particular, nearly 100 proposals were submitted in each of those states over an 8-year period. That's a lot. I mean, like, that's a lot of legislative business, right? This is coordinated effort here. So those proposals, right? Many of them limit court funding. They may constrain court jurisdiction. They may allow legislative override of judicial decisions, alter the selection methods that are used to staff the bench. They may impose term limits or age restrictions. They may impose liability for judicial decisions. There are several states now that have put forward legislation that tries to say basically, hey, if you're a judge and you make a decision, you can be criminally liable for that decision.
Rachel?
Yeah.
Didn't the governor change the makeup of the commission in Iowa?
We're getting there. We're getting there. I know we're going a little late. Yeah, I'm sorry about that. I promise we're almost done here. Right. But we see that all of those legislative proposals are much more common in states like Iowa that use merit selection, right? So it's a systematic kind of effort to undo some of the provisions that have attempted to keep political influence out of the courts. And in Iowa, we've seen this. It may seem like a very small change, but in 2019, the Iowa legislature altered the makeup of the statewide nominating commission. They're the group that vets candidates for the Iowa Supreme Court and the Iowa Court of Appeals. That change allowed the governor to appoint a majority of commissioners, and therefore it gives the governor greater control over the commission. It also eliminated a rule that had a sitting Supreme Court justice chair the commission. Again, this may not seem like a big deal, right? But now that the governor's appointees have a majority on the commission, it makes it virtually guaranteed that an appointee of the governor will chair the commission as well. They will select their own chair now. So the majority will select someone. And this year, a similar bill was introduced that would have made that same change to all district court nominating commissions across the state of Iowa. So I want to be clear that a lot of great people serve on these commissions. I don't want to demean their work at all. But there's absolutely no question that a series of proposals have been put forward in Iowa, and they would actively give the governor greater influence over the process of selecting judges, presumably to enable the appointment of ideological allies. And that's not a stretch. That's a political force that has been with us all the way back to the election of 1800. Right? This is a very common thing. If all of this seems super depressing to you, I get it. I get it. If you're feeling there's nothing to be done about any of this, the monster's taking over, you're ready to just succumb and say, I can't do anything about it. It's a lovely day. I want to go outside and take a walk now. Make her stop. I'm going to hope that I can pull you out of that little tailspin. Our courts matter, and they matter a lot. And they matter most to the people who end up standing in front of a judge, right? And those people often don't have a lot of political power. Oftentimes, those people are the least among us. And so I believe that we have a responsibility to step up and protect the interest of every single person who will walk into a courtroom today, tomorrow, next week, next year. They should know unconditionally, without question, that the court will treat them with dignity and respect, will listen carefully to their case, will hear the arguments, and will render a fair decision. And so in terms of how do we make that a reality, how do we participate in the process, I would say, first of all, we need to know, like really know, that sometimes a fair court reading the law and faithfully interpreting the law relative to the facts of a specific case may render a decision that we personally do not agree with. It doesn't seem intuitively right to us, right? But it doesn't serve our courts well if we only get upset and we only talk about courts when we don't like a ruling, right? If that's our only interest, then we're playing politics as much as everyone else is. What we can do is look for patterns of political decision making. And when we think we see one of those, I think we need to step back and we need to assess whether it's a systemic problem before we accuse the court of wrongdoing. And I think that also allows us to think about problems and questions of institutional design. If we just want courts to make political decisions that we agree with, and not make political decisions that we do not agree with, we can advocate for changes that will make that happen, but it's short-sighted, right? Ultimately, it will come around. So instead, I think we need to concentrate on efforts that anticipates unintended consequences, make sure that we're not exacerbating the problem, and make sure that we're not kind of unintentionally making the courts more political. So in assessing that, I think one of the things we need to do is we need to become court nerds. I'm going to encourage you to become a court nerd. It's fun. I'm a court nerd. It's great. Right? So what that means is assessing what those small changes are and why they could matter, right? Thinking not in terms of the big things, but fighting for seemingly small things, like a change in how many commissioners the governor appoints. That's nerdy, really nerdy, but it matters. So sometimes big change matters less than a series of small changes. And realizing that and paying attention to our judicial system rather than just individual judicial decisions, right? I think that's where we need to be focusing. Being aware of those opportunities for small scale attention and small scale action to protect courts. It may not be sexy and it may not be exciting, but it can yield really dramatic results. So be a court nerd. And finally, I'm just going to ask you to be a constituent of the courts. The courts face a really unique problem. And it's a fundamental political problem, right? And that is that there are lots of constituencies out there that have an interest in politicizing our courts. But there's no natural constituency to protect our courts. And so I'm going to ask you to become part of a constituency to protect our courts. And that means being a court nerd, right? But it also means, right, really thinking carefully about what you can be doing as an advocate to preserve fair and impartial courts. So I will stop there, and I'm sorry I ran long. So
Totally fine. Normally I bring the microphone around to you, but today we have a different system. And so if you have a question or a comment, I actually need you to come here.
Oh.
I know, like change and all of that. It's hard. And so you can come up one by one. It'd be better if there are at least a couple people so we can just move on. And I'm going to let Libby be the first question.
Clarence Thomas's
Yes.
close personal relationship with Harlan Crow.
Mhm.
He says he doesn't have to report
Recuse
any of
himself.
that.
Yep.
Help us.
He doesn't. The current ethics rules for the U.S. Supreme Court allow justices themselves to determine whether or not there is a potential conflict of interest that would suggest that they should recuse themselves. And so, I mean, I think this is one of those relatively nerdy issues that a lot of people haven't paid attention to for a very long time. It is completely appropriate to think about how the ethics rules for other federal judges can be applied to the U.S. Supreme Court. There's a fundamental political problem there too, right? Because anything that Congress passes to increase ethics provisions for the U.S. Supreme Court will be subject to review by the U.S. Supreme Court, right? Like, but I mean, it's certainly as a public signal of yeah, of goodwill in terms of fostering effective, fair courts. I think it's completely appropriate for Congress to pass an ethics law.
The fact that his wife is on those same trips.
Yep.
Jimmy Thomas.
Yep.
Whose influence is incredible.
Mhm.
Yeah.
Yep. And that's something, I mean, there can be ethics rules. And other federal judges exist under ethics rules that have been promulgated by the Supreme Court and the Judicial Conference of the United States, which is led by the Chief Justice. And so it'd be completely appropriate for either the federal judiciary itself or Congress to consider enhanced ethics rules for the U.S. Supreme Court. And they've brought it on themselves, right? I mean, like, it's one thing to operate under informal norms and rules that you've adopted for yourself and do it in good faith and, right, not take advantage of the lax rules. But in this case, there's no question that there's a real problem.
But since they don't talk politics.
They never talk politics
Well,
together.
When you make comments like that, then people online can't hear.
Oh, okay. Sorry.
So we're gonna go over here.
I just have two questions.
Sure.
The first one, what are your thoughts about expanding the U.S. Supreme Court? And the second one, in Wisconsin, does the legislature have the authority and a process for impeaching a judge, their own Supreme Court judge, which could happen next week?
Yep. Yes. So we'll start with the first one because it's easier. Yes, Wisconsin has a process by which the legislature can impeach a judge. Most states have a similar system where there's a way to remove a judge from the bench. Typically, there are some pretty detailed conditions under which that would apply, which do not apply right now in Wisconsin, but presumably politically motivated legislatures could could at least attempt it. I don't know if they'll be successful or not. And then in terms of expanding the court, I worry about expanding the court largely because I think it would be done for political purposes, right? I think it's pretty clear that those who are advocating expansion of the U.S. Supreme Court are doing it because they're unhappy with the current rulings and they would like to see different justices deciding cases. But, you know, if you set that precedent, then any future political group that that is unhappy with the court's rulings can similarly say, oh, we're just going to create more judgeships, right? And pretty soon you have a pretty unwieldy court. And I don't believe anyone in that circumstances, right? If you think into the future, you think about the unintended consequences, you think about what's likely to result from that. I see a kind of an untamable beast of let's just kind of keep appointing new justices that we like to alter the balance of power until you render the court completely political and politicized. I think there are other ways that you could potentially think about, addressing the makeup of the court and or the process of appointing new justices that might be more fruitful. Like there have been conversations about potentially using the same process that the Court of Appeals uses to randomly select a panel of judges to hear a case rather than the court, all 9 justices hearing every case. So there've been another proposal to actually actively include in some sort of similar randomized panel system to include Court of Appeals judges in that process. So you diversify the number and kind of judges who could potentially be a part of those panels. So I think there are a lot of weird little tweaks that you could do that might change the dynamics of the bench. But creating new judgeships, I think that just creates a really dangerous precedent that takes us into the future in, kind of an untamable way.
And state Supreme Courts and is there, I guess, kind of an ideal number of justices that seem to work, or some variation that seems to work?
Yeah, so most Supreme Courts, state Supreme Courts, have somewhere between like 7 and 12 justices, and that's pretty in line with the U.S. Supreme Court. It's amazing to me because the federal judiciary is so underspecified. There are a number of states that are similarly underspecified, but the norm of the federal system has kind of occupied our mind, right? And so if you just ask people, like, what's the ideal size for a Supreme Court? A lot of people are going to be like 9. The U.S. Supreme Court has not always been 9 justices. You could potentially have 50 judges on the Supreme Court, right? But these norms kind of seep into our consciousness as if they are wise and well considered, even if they're not. So yeah, typically, right, the court, yes, state Supreme Courts are somewhere between 5 and 12, or 7 and 12, and it kind of gives I don't believe that there's any good research on whether the smaller end of that is more effective than the larger end of that scale. So, yeah.
We're very aware here in Iowa that one of our senators had a lot to do with the reason that so many judges got appointed in the next administration. But why were so many openings available for them to fill?
So this is kind of a convoluted political story. I mean, a lot of those vacancies were available precisely because the Republican Senate didn't confirm a lot of President Obama's nominees. And so there were a huge number of vacancies. And in fact, many federal courts at the beginning of the Trump administration were quite literally, officially in emergency. Right? They simply couldn't process the caseload that they had in front of them. And so there was a ton of work that needed to be done in terms of filling those seats. And this is, right, the fact that the Senate wasn't confirming President Obama's nominees was what, motivated Harry Reid to initially use the nuclear option to get rid of the filibuster for lower court nominees. And that was one of those things, literally, on the day that happened, I was in judicial politics class and I said, this is how Roe v. Wade falls. Right here, right now, this is how it happens. If you're going to use the nuclear option for lower court nominees, it will serve as a precedent to do it for Supreme Court appointments. It will make it easy for the next president to stack the bench, right? And that's exactly what happened, right? So this is one of the reasons I think we have to be very wary of large-scale changes to address immediate political concerns, because I think we end up sometimes making changes that ultimately don't serve us or our courts well. So, yeah, clearly there was a backlog. It was already a problem. The way it was dealt with was maybe ultimately created more problems than it solved.
Kristen, are there any questions online?
Nope.
We have one last question in the room.
Yeah,
Hi.
I just wondered if you think there's any chance or if it's even possible or makes sense to do term limits for the Supreme Court.
For the U.S. Supreme Court, I think it would be very difficult because of the Constitution, right? The Constitution sets the terms for U.S. Supreme Court justices as good behavior, right? And so as a result of that, that's been interpreted to mean lifetime tenure. So it would require a constitutional amendment to set kind of, year-based term limits instead of performance-based term limits. I think you could. Well, I don't know. I'm not a lawyer, so I don't know how you get around that language. So yes, I think it would require a constitutional amendment. I think it'd be very difficult to do, to achieve. Other questions? No? Have I depressed you all mightily? It's a beautiful day outside, so hopefully you're going to step outside and any ill feelings are just going to go away. They're going to leave you and you're going to feel great.
Well,
Thanks.
Thank you so much, Rachel, for all of your work and all your expertise and for driving over from Des Moines and all of the good things. So really grateful. I will point out that Justice Not Politics, as I mentioned earlier, is the organization that Rachel and I both serve on the board of. It is the only statewide organization that focuses solely on fair and impartial and independent courts at the state level primarily. So would encourage you, if you don't know about Justice Not Politics, you can check us out. And website, Facebook page, all the Twitters and that kind of stuff. So
And if you want to be a judicial nerd, Justice Not Politics is a good way.
we are a bunch of judicial nerds. So and always provide a lot of good information on what's happening, not only in the state, but what's happening around the country as well. So I would encourage you to find that organization as well. And from now, thank you for being in the room. Thank you for being online. We really appreciate you being here. And I hope that you will join us the first Friday in May. Thank you so much and have a great weekend.